If you care about the survival of American institutions, you need to pay attention to what I'm about to tell you. Subscribe to this channel right now and turn on notifications, because what happened today in a federal courtroom in Manhattan isn't just a legal story. It's a stress test on whether our democracy can actually function when someone decides the rules simply don't apply to them. Here's what we know. At approximately 11:47 this morning, in the middle of active federal court proceedings, three of the highest-paid defense attorneys in America stood up from the counsel table, gathered their papers, and attempted to walk out of the courtroom while a federal judge was mid-sentence. Let me say that again so it lands properly. Licensed officers of the court, sworn to uphold the Constitution, tried to physically abandon their client and flee a federal proceeding because they didn't like a ruling. What happened next is something that hasn't occurred in a federal courthouse in over 2 decades. Let me take you through the sequence of events, because the details matter enormously here. The morning session began with what court observers described as routine procedural arguments. The prosecution was seeking to admit certain financial documents. The defense was objecting. Standard stuff for a case of this complexity. But here's where you need to understand the context. 48 hours before this hearing, something happened that we only know about because of a clerical error. A sealed filing was accidentally uploaded to PACER, the federal court's electronic records system. It was visible for exactly 17 minutes before being removed. In those 17 minutes, legal researchers captured the filing. What did it contain? According to multiple sources who reviewed the documents, the prosecution had submitted new evidence consisting of encrypted communications between Trump and his co-defendants during what the defense had previously characterized as a blackout period, when they claimed absolutely no contact occurred. The documents allegedly included wire transfers totaling $4.7 million, and what one source described as the most damaging paper trail ever assembled in a white-collar criminal case. This morning, Judge Patricia Caldwell ruled all 847 pages admissible. That's when everything fell apart. Lead attorney Robert Sterling rose from the counsel table. Court reporter Maria Rodriguez captured every word. Sterling allegedly stated, "Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial." His co-counsel Jennifer Matthews added, "This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence." And then they started walking toward the door. Now, I need you to understand something about federal courts. Judge Patricia Caldwell is a Reagan appointee. She has served on the federal bench for 31 years. She is known universally for her measured temperament. Defense attorneys generally consider drawing her a stroke of good luck because she runs a fair courtroom. This judge looked at 3 attorneys attempting to abandon their client mid-trial and said the following words, which are now part of the official record: "Counselors, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then ordered United States Marshals to block every exit. 6 armed federal marshals positioned themselves at all doors within seconds. The standoff lasted exactly 7 minutes and 23 seconds. If you're finding this valuable, hit that like button right now, because this story is about to get significantly more complicated. Here's what Judge Caldwell revealed that explains why Trump's attorneys were so desperate to escape that courtroom. According to sources with direct knowledge of the proceedings, the judge announced she had received a sealed ex parte submission from the Department of Justice that very morning. For those unfamiliar with legal procedure, let me explain why this matters. Ex parte means only one side sees the submission. Federal judges almost never allow ex parte communications. They are reserved almost exclusively for matters involving national security or witness protection. Judge Caldwell stated on the record that based on this filing, she was considering enhanced security measures and potentially sequestering the jury. Every experienced criminal defense attorney in the country immediately understood what this meant. The prosecution has a cooperating witness. Someone in Trump's inner circle has flipped. Former federal prosecutor Andrew McCarthy told Fox News within hours, "When defense attorneys hear about a sealed ex parte submission in a case of this magnitude, they know the walls are closing in. Someone on the inside has turned, and they're about to drop a bomb the defense never saw coming." The panic suddenly makes complete sense. Let me connect some dots here, because this is where the story moves from legal drama to something far more consequential. Court documents show that within 30 minutes of returning to their seats after that 7-minute standoff, Sterling's team filed an emergency motion for a mistrial citing judicial bias and prosecutorial misconduct. They simultaneously filed a motion to recuse Judge Caldwell, arguing that her threat of arrest demonstrated personal animus toward the defense. Do you see what happened here? By creating this dramatic spectacle, they have effectively manufactured grounds for multiple appeals regardless of how this trial ends. Every legal expert analyzing this situation agrees on one point. This was theater designed for an audience far beyond that courtroom. And here's the evidence that suggests this was coordinated. Sources say Fox News had camera crews positioned outside the courthouse 45 minutes before the walkout occurred. Several conservative commentators were tweeting about judicial tyranny before news of the incident had even gone public. How did they know something was going to happen? Subscribe now if you want to follow where this investigation leads, because the implications are staggering. That sealed ex parte submission Judge Caldwell mentioned. Department of Justice sources indicate it pertains to testimony scheduled for next Tuesday from someone referred to only as Witness 14 in court filings. This individual allegedly has direct knowledge of the financial transactions at the center of the government's case. This individual has been in protective custody since October. The defense team's dramatic walkout occurred exactly 96 hours before this testimony is scheduled to begin. Coincidence? The timing tells you everything. Legal analysts are speculating about who Witness 14 might be. The leading theory points to someone in Trump's inner financial circle, a CFO or controller with direct access to the allegedly fraudulent transactions. Protective custody since October means someone with serious safety concerns. That level of protection is typically reserved for cases involving organized crime or national security matters. If this witness delivers the testimony prosecutors are anticipating, it could be catastrophic for the defense. After the standoff ended and attorneys returned to the counsel table, Judge Caldwell delivered a statement that shook the legal community. Given counsel's attempted abandonment of their client mid-trial, I am considering appointing shadow counsel to ensure the defendant's Sixth Amendment rights are protected. Shadow counsel means the court would assign backup attorneys to sit at the defense table, ready to take over instantly if the current team attempts to withdraw. It's essentially the legal equivalent of having understudies in a Broadway show, except the stakes are someone's freedom and potentially the integrity of the American justice system. The financial consequences are already materializing. Sterling's law firm has billed over $12 million in legal fees, according to FEC filings. Late Friday evening, Bloomberg reported the firm had entered emergency talks with its malpractice insurance carrier. Sources indicate the carrier is concerned about potential liability if the attempted walkout leads to a mistrial or successful appeal. Industry insiders suggest the firm's coverage could be at risk, potentially exposing partners to personal financial responsibility. This would explain why senior partners were seen arriving at the Manhattan offices at 10 p.m. Friday night for what was described as an emergency crisis management session. Hit that like button if you understand why this matters beyond the immediate case. Here's why what happened today threatens something far larger than any single trial. If attorneys can simply walk out whenever rulings don't go their way, the integrity of the entire judicial system collapses. Judge Caldwell seemed acutely aware of this when she stated, "The court will not permit counsel to manipulate proceedings through calculated disruptions. Such tactics, if successful, would encourage every losing party to manufacture a mistrial through counsel withdrawal." She's absolutely correct. Once that door opens, any defendant facing conviction could instruct their lawyers to storm out and claim the trial is unfair. In modern American legal history, there are only 3 comparable instances of defense attorneys attempting to abandon clients mid-trial in federal court. In 1978, mob lawyer Frank Ragano tried to walk out during the Santo Trafficante trial. He faced disbarment threats. In 1992, during the BCCI banking scandal, 2 attorneys attempted to withdraw but were forced to continue under threat of contempt. In 2009, Bernie Madoff's original legal team tried to quit 2 days into testimony but were compelled to stay. In all three cases, the defendants were ultimately convicted. In all three cases, the attorneys faced severe professional consequences. The pattern is clear. The political fallout was immediate. Within minutes of the walkout attempt, Trump's Truth Social account posted, "My lawyers are fighters who won't stand for this rigged trial. Judge threatening arrest, election interference." The post accumulated over 2.3 million views in the first hour. Republican senators quickly weighed in. Senator Tom Cotton tweeted, "When judges threaten to arrest attorneys for defending their clients, we've entered banana republic territory." Senator Elizabeth Warren countered, "No one is above the law, including lawyers who try to sabotage judicial proceedings." But here's what's telling. A flash poll conducted Friday evening by Reuters Ipsos found that 67% of Americans disapprove of the lawyers' walkout attempt, including 48% of Republicans. 72% agreed that no one should be above the law, including former presidents. Even some of Trump's staunchest legal supporters are struggling to defend this. Alan Dershowitz told Newsmax, "Walking out on a federal judge is simply indefensible. There are proper channels for addressing grievances. Abandoning your client mid-trial isn't one of them." When Alan Dershowitz won't defend you, you've crossed a line that most people didn't know existed. Here's a detail that hasn't been widely reported. A paralegal for the defense, speaking on condition of anonymity, revealed that Robert Sterling received a text message at 11:42 a.m., 5 minutes before the walkout. The message contained two words: Abort Mission. The source claims the message came from a senior Republican strategist advising the team on public relations strategy. If true, this raises the possibility that the entire dramatic scene was orchestrated for political purposes rather than legal ones. Judge Caldwell appears to have reached a similar conclusion. In a written order issued Friday evening, she included this striking passage. "The court has reason to believe that certain theatrical elements of today's proceedings were coordinated with outside parties for purposes unrelated to the fair administration of justice. Any future attempts to transform these proceedings into political performance art will be met with the full range of sanctions available to this court, including but not limited to contempt charges, financial penalties, and referral to appropriate bar authorities." A federal judge is now on record stating she believes today's courtroom drama was political theater coordinated with outside parties. Let that sink in. After this morning's chaos, the U.S. Marshals Service elevated courthouse security to its highest level. Additional metal detectors were installed. All visitors faced enhanced screening. NYPD deployed additional units around the perimeter. The FBI's New York field office reportedly placed agents on standby. This is not standard procedure. During the afternoon session, a note was passed to Judge Caldwell prompting an immediate sidebar. Sources say the note came from court security, alerting the judge that several individuals tied to far-right militia groups had been identified near the courthouse. While no specific threat was confirmed, their presence added another dimension to an already volatile situation. The judge reportedly warned both legal teams that any attempt to incite public disorder would be met with the full force of federal law enforcement. The ripple effects have extended far beyond American borders. European legal observers express shock at the courtroom drama. The UK's former director of public prosecutions commented, "In any common law jurisdiction, such behavior would result in immediate custody." French media ran headlines translating roughly to "American justice in chaos as Trump lawyers defy judge." Russian state media predictably seized on the story, framing it as evidence of institutional weakness in the United States. The fact that these attorneys felt emboldened to attempt such a stunt underscores a troubling erosion of respect for judicial authority that has implications far beyond this case. If you're still watching, subscribe to this channel because what I'm about to tell you is the most important part of this entire story. Sources close to Trump's inner circle now indicate serious discussion about replacing the entire legal team. Names being floated include some of the most controversial lawyers in the country, attorneys who have defended war criminals and terrorism suspects. The apparent strategy, if we're going down swinging. This puts Judge Caldwell in an almost impossible position. If she allows Sterling's team to withdraw now, the trial could be delayed for months while new counsel comes up to speed. If she forces them to continue against their will, she creates massive grounds for appeal based on ineffective assistance of counsel. One former Supreme Court clerk called it brilliantly cynical. The defense has engineered a situation where the judge has no good options. Meanwhile, sources say the prosecution is preparing what's being called a nuclear option, asking the judge to revoke Trump's bail based on his lawyer's conduct. The argument: anyone whose legal team attempts such disruption poses a flight risk and threatens the orderly administration of justice. While extreme and almost certain to fail, even attempting this move would generate headlines and shape public perception of what's actually happening in that courtroom. Consider the impact on the 12 citizens who will ultimately decide this case. While the jury wasn't in the courtroom during the walkout itself, the tension in the afternoon session was impossible to miss. Juror number 7, a retired teacher from Brooklyn, was observed repeatedly shaking her head during defense arguments. Juror number 3, a small business owner, appeared to be taking extensive notes whenever the judge addressed the defense team. Jury consultant Dr. Patricia Williams told CNN, "When jurors witness this level of conflict between a judge and defense attorneys, they often interpret it as consciousness of guilt. Why else would lawyers risk their careers unless they knew their client was in serious trouble?" The defense may have won some procedural battles today, but they may have lost the war for the jury's perception. Monday morning, Judge Caldwell will rule on the defense team's motions for mistrial and recusal. She will decide whether witness 14 will testify as scheduled. If Sterling's team attempts another disruption, she has made clear they will face immediate arrest. The U.S. Marshals have reportedly been briefed on arrest procedures for attorneys, a step that sources say has not occurred in a federal courthouse in living memory. Consider the timing of all of this. With just 11 months until the 2024 election, every day this trial continues is a day Trump cannot fully focus on campaigning. Some political analysts argue the walkout was designed specifically to force a mistrial, pushing any retrial past the election. It's a high-risk, high-reward strategy that treats the courtroom as just another political battlefield. Judge Caldwell appears determined not to let that happen. Sources familiar with her thinking say she's prepared to hold court sessions 6 days a week if necessary to keep the trial on track. She's also reportedly considering limiting media access if she believes coverage is encouraging theatrical behavior. What we witnessed today wasn't merely a legal maneuver. It was an attempt to transform American courtrooms into political theater. When attorneys feel empowered to walk out on federal judges without consequence, when defendants treat criminal trials like campaign events, when justice becomes indistinguishable from reality television, we have crossed a line that our constitutional system may not be designed to handle. Even Republicans are beginning to distance themselves from these tactics. Senator Mitt Romney issued a statement. Respect for our judicial system is fundamental to our democracy. While everyone deserves zealous representation, attempting to flee a federal courtroom crosses every conceivable line. Even Senator Josh Hawley, typically a staunch Trump defender, emphasized that attorneys must follow proper procedures when asked about the incident. When you start losing the Josh Hawleys of the world, your legal strategy has fundamental problems. The real damage here extends far beyond any verdict in this case. Every American deserves competent counsel and a fair day in court, operating within established rules. When those rules break down, when lawyers literally attempt to flee rather than face adverse rulings, it signals that our system can be manipulated by anyone with sufficient resources and audacity. That's not justice. That's chaos wearing a suit and billing by the hour. The stakes go far beyond one trial or one defendant. If Trump's team succeeds in turning criminal proceedings into political circuses, every wealthy defendant in America will be tempted to attempt the same tactics. Imagine trials where any well-resourced defendant can instruct their lawyers to walk out whenever a ruling doesn't favor them, where proceedings become performance art for social media rather than genuine searches for truth, where judges must threaten arrest simply to maintain basic courtroom order. That's not a justice system. That's the end of the rule of law as a functioning principle. The question now is whether Judge Caldwell can restore order, whether Trump's legal team will continue their disruptive tactics, and whether our judicial system can survive this unprecedented assault on its core principles. Make sure you're subscribed with notifications turned on because this story is far from finished. When witness 14 takes the stand, when Judge Caldwell rules on the mistrial motion, when we finally learn who sent that abort mission text, you'll want to know immediately. Hit that like button. Leave a comment telling me what you think happens next. And share this video with anyone who cares about whether American democracy can survive what's being done to it. This isn't just about one trial or one defendant anymore. It's about whether we still believe, genuinely, functionally believe, that no one in this country, no matter how wealthy, no matter how powerful, no matter how politically connected, is above the law. The answer to that question will shape this country for generations. I'll see you Monday when the judge rules.